You're watching The Legal Breakdown. So, Glenn, we've got some instant bad news for Donald Trump in his ongoing effort to do whatever possible to delay the start of his first criminal trial in New York. So he tried to do so again today by appealing his gag order to a New York appeals court. Talk about what just happened.
Yeah, instant, I think, is exactly the right word, because this is probably the third or fourth time Donald Trump has desperately tried to delay the commencement of his trial, scheduled to begin on Monday, April 15th. And they made oral arguments to one judge on the New York appeals court. And literally within moments of the argument concluding, the judge said to Donald Trump's lawyers, "Denied. We will not delay this trial." So now the next step, because there's always another frivolous appeal in Donald Trump's back pocket, they will be appealing this decision by one judge to a 5-judge panel, and that will happen on Monday. But as of right now, there is absolutely no impediment to the jury trial beginning on Monday.
Well, Glenn, now that this decision will go to the full appeals court panel, could that delay the start of this trial, waiting for them to take up this issue?
Yeah, it's kind of the perfect question because, Brian, as of right now, you know what Monday's going to look like? It will be the first day of jury selection in Donald Trump's first criminal trial, and it will be one or more of his lawyers appearing in another courtroom, an appeals court in New York, before 5 appellate court judges trying to put a stop to the very trial that is underway with jury selection in another New York courtroom. I mean, this is like a bizarre practice of criminal law. You know, if the first Donald Trump criminal trial was an action-adventure movie, we would kind of be in that last car chase scene where we're all on the edge of our seats trying to figure out, okay, is the bad guy's car going to careen off the cliff and the good guy's car going to come to a screeching halt before it goes off the cliff? I mean, this is kind of the legal equivalent of that at this point.
Well, you just mentioned that both parties will be in court on Monday. What happens if the appeals court agrees to stay the trial once it has already begun and jury selection is underway?
One of two things will happen. They will either direct the trial court, the trial that's being presided over by Judge Merchan, to pause jury selection, and then they will resolve the argument that they've heard on Monday, the 5 appellate court judges, or they will direct that the trial just stop in its entirety. And once you start jury selection, there's no legal impediment to stopping, and then a week later, a month later, bring in a new batch of jurors and begin jury selection anew. Really, the most critical phase of the trial for double jeopardy purposes is the moment the jury is sworn. When does that moment come? Not during the week or two of jury selection. It's after there have been 12 jurors selected by the parties and a series of alternates. The minute the judge or the judge's clerk administers the oath to the 12-person jury, that is the moment jeopardy attaches. So there's actually a good bit of leeway to start jury selection, pause it, or just stop it entirely and start it anew in the future without any risk of jeopardy attaching. But like I say, on Monday, I think we are going to know pretty definitively whether Donald Trump's first criminal trial, the first trial of a criminal former president of the United States, is up and running. And I have a feeling it will be, Brian. The way the one appellate court judge decided the issue so quickly, so definitively, I have a feeling that's important foreshadowing for what we're going to see all 5 appellate court judges do on Monday.
Right. In theory, you can assume that her logic for handing down this decision was airtight enough that it would also kind of be the same logic that would be used by the full panel.
Yeah. And let's face it, Donald Trump, his desperation is showing because he is trying anything and everything to delay the trial. I mean, he's tried over and over again with respect to multiple different issues, and the courts are shooting him down every time.
Now, can you do a quick rundown of the ways in which Trump has sought to delay this trial just in the last couple weeks? Because I know there's kind of it feels like we've been talking about this so much, but there's actually different avenues that he's been employing.
Yeah, and it's hard to keep track of them all and exactly where each one is in the system. But here's what we know. Donald Trump has filed not one, but two motions to recuse Judge Merchan, that is, to remove him from presiding over the case entirely. Both of those motions have been rejected. He also filed a lawsuit. And can I tell you just, Brian, filing a suit against the judge who's presiding over your criminal trial is not a thing in the practice of the criminal law. I never saw it once in 30 years. I'm not saying it can't be done. I've never seen it done personally in my practice. And even if it can be done, I can't imagine it's ever done successfully. And that's what Donald Trump is experiencing. He filed a suit to try to pause the trial while the appellate court takes up the issue of the gag order. And that's the one that was just resolved on Tuesday by the single judge. But the judge says, fine, I'm not going to pause the start of the trial, but y'all can come back on Friday and give it one last try. I predict that will be unsuccessful for Donald Trump as well. He also filed a motion to change the venue. What does that mean? He argued that because there are so many Democrats in Manhattan, I can't possibly get a fair trial here, so I want you to move the trial to a jurisdiction where there are mainly, or at least a greater number of, Republican voters. That's not actually a basis for moving the trial, for changing the venue. It would be a basis if there was so much publicity about a trial that was perhaps of local notoriety, and you could move it to another part of the country where nobody heard about it. Of course, given Donald Trump, who he is, what he's done, this has gotten worldwide publicity, never mind all around the United States. So his political reason for wanting to have the trial moved from one venue to another, from one jurisdiction to another, was filed, was argued, was rejected also by the appeals court. So I think that covers the landscape of the various motions that Donald Trump filed, sometimes the same motion repeatedly, trying to delay the commencement of his trial. But as I say, everything right now looks like it's on track to begin on April 15th.
Glenn, can you talk for a second about the dichotomy of the strategies between the two sides? Because you have Donald Trump's team who is so hostile to the judge that they will actually sue them in mid-trial before the trial even begins in earnest. And then you have Jack Smith, who's contending with someone who isn't even close to acting in good faith in Judge Cannon. And he's so carefully tiptoeing around her that even though she has proven time and time again that she's willing to interfere on Donald Trump's behalf, still he hasn't moved forward and sought a removal motion with the 11th Circuit.
Yeah, you know what? It's kind of a great comparison and contrast, and we're mixing criminal apples and oranges here because, of course, what Donald Trump is doing right now is in a desperate attempt to stop his New York criminal trial. What Jack Smith is doing is contending with a judge, Aileen Cannon, in Donald Trump's federal prosecution in Florida for unlawfully retaining classified documents, obstructing justice, and violating our nation's espionage laws. But boy, the approaches of these two teams could not be more different. Donald Trump is pulling every trick in the book. I mean, this really is not good faith litigation that Donald Trump is engaged in. These are kind of legal dirty tricks that he's playing to try to put a stop to what is a legitimate trial date. And down in Florida, Jack Smith, in my opinion, Brian, has every reason to file a motion to kick Judge Cannon off the case, not just because she was appointed by Donald Trump. She's now presiding over the case involving the defendant who gave her job, and not just any job, a lifetime appointment to the federal bench. That is one cushy job. And I would say that in those unique circumstances, any other judge should preside over the case rather than a judge that was appointed by the defendant. Now, there's no rule or law that applies to that. Why? Because we've never tried a former president of the United States for crimes they committed. But on top of that, Judge Cannon has shown herself to be biased in favor of Donald Trump over and over and over again with these really inexplicable rulings that she has come up with. And yet, Jack Smith seems perfectly content to have her remain the presiding judge on the case because he has deigned not to file a single challenge to her competence or to her ability to be fair and impartial. I hope to heck that changes, Brian, because, Judge Cannon has so exposed herself as being incapable of sitting in the case fairly and impartially the way she continues to do these favors, including sometimes lawless favors, because the appellate court has once said she abused her judicial authority by ruling in a way that acted to the extreme benefit of Donald Trump. We want to be able to have confidence in the outcome of the trial in Florida. And as of right now, I would have no confidence in the outcome if Judge Aileen Cannon presided over the trial. Now, she hasn't even set a trial date, even though she has been asked to, which frankly also goes into the disqualification bucket. But the only way we can have confidence in the outcome of the case is if Jack Smith files the motion to remove her, it gets litigated in the full light of day with all of the evidence, both pro and con, both supporting that she should be removed and cutting against the argument that she should be removed. Then that whole thing is decided by the 11th Circuit Court of Appeals. And Brian, I generally am willing to abide by the law and by the precedent as handed down by appellate courts. And if the 11th Circuit Court of Appeals, after fully litigating the issue, says, you know what, under the prevailing laws and under the prevailing applicable precedent, we don't think there's enough for her to be removed from presiding over Donald Trump's case, I would be far more willing to then accept the outcome of a trial that was presided over by somebody like Judge Cannon. But without that litigation, I will never have a comfort level, given how Aileen Cannon has already exposed herself as being unfair to Donald Trump's advantage.
Yeah, I think that's exactly right. Let's finish off with this. Glenn, can we get your bet for an on-time trial in New York on April 15th? Because last we checked in, you were at 95 cents.
I think I'm going to, after the very rapid decision by the New York Court of Appeals judge, I'm going to tick it up to about 97 cents, Brian. I'm not at a full buck yet because I'm holding on to those last 3 pennies, but I'm going to put it at about 97 cents on my betting dollar.
All right, well, I think most of us will take 97 cents any day of the week. So with that said, we'll, of course, stay on top of this in this last week now, where Donald Trump will try everything he can to delay this trial. And, of course, by Monday the 15th, we'll have an answer here. So for those watching, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.